Hello everyone, I'm Robin Pickworth. I'm a partner in the litigation department at Rudnick in London. Some good or bad news, depending on how die-hard you are on these things. We're going to try and finish this by about 4:45, just because a couple of our panelists have got other commitments that they can't move. So this is a panel about collective redress in Europe. As I'm sure most of you know, EU member states were required by last June to implement and put in place the directive on representative action. That requires EU member states to have in place at least one procedural mechanism which enables consumers to seek redress, including compensation where certain EU laws have been breached. Here we are 9 months later. I think that's very much, as you'll hear, a work in progress across member states. This panel is going to consider the landscape for collective action in Europe, both in relation to collective claims for consumers, but also in relation to collective claims made by businesses outside the scope of the directive. We've got leading practitioners from the Netherlands and Spain, where perhaps the funding market is a bit more mature. We've also got leading practitioners from France and Italy, where the landscape is developing fast. We're also lucky to have a global legal assets business here on the panel, and they will help us understand what different jurisdictions they find attractive and why. So with that said, I'm going to hand over to my panel and ask if you could each introduce yourselves. Alberto, do you want to start?
Yes, thank you. Alberto Toffoletto. I'm a lawyer, an Italian lawyer, and a partner of Advant Nctm in Milan.
My name is Carlos Ara. I'm a partner at CuatreCasas, a Spanish law firm, and I lead the litigation finance practice.
My name is Quirijn Bongaerts. I'm one of the founders of Birkway in Amsterdam, the Netherlands. We are a claimant-only law firm. We mostly specialize in Dutch class actions and mass claims, some other work, but that's mostly what we do. That's it.
Hi, I'm Rosie Ioannou. I'm a managing director in the legal assets team at Redress, who is a litigation funder.
I'm Marc. I'm based in Paris. I'm a co-founder of Brandeis Paris, and I focus on collective actions in France and competition claims.
So I think a good place to start is if we get a sense of the state of play in each of your jurisdictions. So if you can perhaps explain to us what stage the directive is at in your jurisdiction, whether there has been an uptick in consumer collective claims in your jurisdiction, and then perhaps contrast that with the state of play for business-to-business collective claims in your jurisdiction. Do you want to begin on that? Because obviously,
yeah, by all means. I think the Dutch situation compared to the directive and other member states is a little bit atypical, because the Netherlands had a collective redress system in place already before the directive. However, that came with the restriction that claims for damages were not permitted. So claimant organizations, often referred to as foundations or stichtings in proper Dutch, could only claim for declaratory relief, and then for damages one would have to file individual claims for damages. And next to that, we had this Collective Settlement Act, which allowed for a court-approved settlement, which would then bind all affected parties on an opt-out basis. So we had that, and because of this old system was a little bit soft in nature and not that effective, because one could not sue for damages on a collective scale, there was a legislative overhaul, one could say, and that is when this new regime was being prepared and then introduced in 2020, and that's the regime which is often referred to as Banca, which allows claimant organizations to sue for damages. So that's a major achievement in a way, but that was of course before the directive and its transposition. And already at the time of the preparation of the Banca bill, the legislature commented that it was actually anticipating the transposition of the directive. So when the directive was there, the only thing we needed was a couple of tweaks, and these couple of tweaks were introduced pretty swiftly. As to the position of consumers, both the old and the new regime were horizontal in the sense that one could sue on behalf of investors, be it retail investors or institutional investors, consumers, personal injury cases, all types of cases in principle could be brought under the class action regime, and that is also the case in the current situation. That brings me to the business-to-business claims as well. Actually, the first case in which a claimant organization sued for damages under the new collective actions regime was a business case, the first case which got certified. And that's, in that situation, it's a case against Vattenfall, the Swedish power supplier. The claimant organization is funded by Benchmark, and in that case we managed to have that foundation being appointed as the first lead claimant. So that was actually a major achievement, but that was a business-to-business case. That was only this fall, by the way.
Congratulations. Carlos, do you want to go next?
Sure, thank you. So, first of all, the directive hasn't yet been implemented in Spain, but we already have some structures in place when it comes to group action, collective actions, either in C2B or in B2B. And that has to do with two main aspects in Spain. So first of all, in Spain it's possible to purchase claims or to purchase proceeds. So we don't have any property or related limitation. And the second one is that there are also no limitations when it comes to contingent fees. So law firms are allowed to take a case on a full contingency basis. That leads to several possible structures to basically book build and file a group action. One is to basically do an opt-in with the claimants directly. That has incremental transaction costs and can have some disadvantages in terms of insolvency issues, personal issues, but that's one possibility. The other one would be to contract with a book builder. That book builder or that law firm can take all the litigation risk on a full contingent success fee basis, and then that law firm can externalize that risk to an investor. In that case, the key issue is the flow of funds to avoid commingling in the event of insolvency and to control the waterfall. And the third main structure relies on an insolvency remote vehicle, which can be an SPV that purchases the claims, and then, assuming that that's a true sale and there are no standing issues, that SPV can bring the claims. And the key advantage of this third structure is that transaction costs are reduced, because in the event of insolvency there is a carve out of the claims in favor of the SPV, and then pursuant to the waterfall, first the proceeds go to the founder of the insurer, and then there is a variable price, an earn-out, which goes directly to the claimants. The implementation of the directive will definitely allow more possibilities, but we already have all those mechanisms in place. And as all of you know, the directive has limited the subjective scope to consumers. So arguably it has fallen a bit short of, because it won't capture other claims like securities litigation, in which individuals arguably don't act as consumers.
Thank you. And Marc, how are things in France?
I think there is a huge distinction to be made between the B2C claims and the B2B claims in France. Regarding the B2C claims and the transposition of the directive, it's currently discussed by the French Senate, and we'll see what comes out of it in the coming weeks. So far, the collective action system for consumers has proved pretty inefficient. As a matter of fact, we adopted in 2014 a law that was a copy-paste of the previous law applicable in the UK, in England, and that proved pretty inefficient. And in 2020, there was a proposal to change that law that was actually adopted just before the directive, and that proposal. And the law adopted in 2014, actually, I think there were something like 30 actions that were brought, and none of them prevailed. So the legislator is currently discussing how to improve things. Now, the transposition is not considering an opt-out system, which would prove, in my view, the only system that would allow huge consumer class actions, or big class actions, like we can see how they develop in other countries. Regarding the B2B market, claims brought by businesses against other businesses, they've been significantly been increasing over the past few years, but also there it's on an opt-in basis. So I think in the past few years there were a number of funded actions by essentially London funders, and there are a number of other actions that are not funded that have been brought, and it makes a huge difference with the landscape a few years ago.
And Alberto, it sounds like things in Italy are still a bit earlier in their phase of development.
You see, in Italy, what happened was that we had the legislation for the class action since 2009, and this old legislation, which was an opt-in system, it is still an opt-in system, also with the new legislation, did not prove to work very well, since we had something like 80 cases, and just 20 of them was authorized by the court to proceed, and just in 5 of them brought at the end, in 15 years, a result of compensation for the damaged party. So it was very unsatisfactory. And in 2001, we had a new legislation, which is of general applicability, so for consumers and professionals, so business, so B2B and B2C. And with this one, we have already a very new wave of activity, because in the last 2 years, we have done something like 30 cases, and they are, most of them are pending. The interesting thing is just 5 of them have been considered not admissible, which means that the test the test provided for by the new law for the admissibility of the claim is different and is wider, and so it's probably easier to bring the claim. Then what happened with the directive was that it has been implemented in 2023 and in June, and the decision of the Italian legislator was different from the Dutch one, because they decided to have a separate set of rules, which in my view it is intended to be more for the to protect the consumer. It's obviously just for consumers, but it to protect consumers through injunction more than with damages. In any case, for the damages, I think that the idea is to use the other general one, and this has been a choice that it has been argued by the authors in Italy, and we will see what will be the outcome. Up to now, in 8 months, we have had 8 cases, and 4 of them are of the same nature, but it's interesting that one of them related to a contribution by a bank in a new co of a line of business has been challenged and was strongly supported also by the publicity. So it was an interesting case, and it will be decided in few days. So we will see.
And on the economic side of bringing collective claims in your jurisdictions, can you help us understand the rule on costs in your jurisdiction? Does the loser pay the winner's costs? And then, perhaps of more interest to the funders, how free a market is it for funders in your jurisdiction? Can anyone fund, and are their returns capped? Alberto.
Okay, so we have a situation where we don't have the contingent fees free as it is in Spain. We have a problem as lawyers, and so there are restrictions. Certainly, there is the risk that the losing party pay the cost of the other party. But it is interesting to say that in class action, consumers cannot be condemned to pay costs unless they acted with fraud of gross negligence. So there is a restriction which is not the general rule. Whether it is a free market in respect of the legitimation to fund, it is argued in these days, because the risk is that the financial legislation come into play. This is an issue, obviously, because then has an impact on the validity of the contract. And so there are at least three possible solutions. One is completely free market, which is used. The other one is to organize, as it has been described for Spain, with the SPV authorized, which is a light authorization, so it's simpler. And the third one is to be organized at the proper fund, which manage the money and raise the money and fund the litigation. It must be considered that also in Italy, as it is in Spain, we have the possibility to purchase the claims, and therefore, especially what we are seeing in this month, I would say, is that in respect of the B2B claims, it is common to organize through the acquisition of the claims and with an earn-out, as it has been described, instead of promoting a class action.
Thank you. And Marc, in France, is it similarly protectionist or perhaps more free?
Well, I think in terms to answer your first question about adverse costs, if you lose a case, you'll only pay a fraction of the actual costs of the adverse party. So in that respect, it's very different from what we see in England, and it's, I guess, very attractive for litigation funders. You will pay some cost, but it has nothing to do if you pay actually 10%, or very often it could be less than the actual adverse cost. That would be the norm. In terms of regulation, there is no regulation of litigation funding so far. I would say that there are a few rules that apply to arbitration, and there are a few precedents that actually authorize litigation funding explicitly, but in other areas, such as in B2B claims, there is absolutely no restriction. So the systems that you describe in order to run a collective action in France, I would say are fourfold. The first type of action is obviously a lawyer being instructed by a number of plaintiffs. This happens very frequently. We have cases, for instance, there is a breast implant case for which there are 15,000 plaintiffs that is actually currently run in France through this system. There is a second system, which is the assignment. You assign your claim to a SPV or to a funder, there is no restriction under the civil code to do that. There is a third way, which is, I think Orphem was the first one to use that, which is the fiduciary system, which is a kind of trust system whereby lawyers are entitled to act as trustee lawyers, and therefore all the claims are put in management into a trust, and it's the trustee lawyer that actually brings the action on behalf of all the claimants. And there is a fourth system, which is the so-called class action system or group action system, where you have an association that actually brings the claim on behalf of a number of claimants, and if the case is won, then all the claimants that want to get some recovery have to ask for that recovery to the association. So it's so far not very regulated. Things might evolve with the transposition of the directive for consumers, but this will not affect the way collective actions are brought for businesses.
And do you see the Dutch courts intervening in the funding arrangements to a greater extent than that?
Yeah, well, that's a sensitive issue. The Dutch courts have not taken a very clear, straight, consistent line when it comes to litigation funding agreements. There have been situations in which actually the parties made an offer to the court: if you do not like what you see, please let us know, and then we can try to fix it. And in some cases, the district court denied that option, which actually meant that the claimant was considered inadmissible, and the only option was to file an appeal. In other cases, actually in a number of cases, the district court has allowed claimant organizations to fix shortcomings in the litigation funding agreement. And that's when it comes mostly to the degree of influence and control of litigation funders over the claimant organization. The other thing is, and it is very clear that the courts have an opinion about that as well, is actually the rate, the percentage, or whatever measure is used for calculating the litigation funders' fees. So we have seen situations in which the district court, again in this business-to-business case, where the court simply accepted that it was 8, 10 or 12%, and they put it in the opt-out announcement, which was published, so everyone who does not opt out is effectively bound by the contingency fee arrangements. That's one thing, so they were very relaxed in that one. In other cases, we have seen that the courts considered, well, the other two claimant organizations charge 25% of the proceeds. One has 27.5. We strongly urge the 27.5 claimant organization to join the line of the other claimant organizations, and it was not a final judgment, but it was just a sort of advice by the district court. And then in the TikTok case, the Amsterdam District Court also gave a sort of preliminary decision. Well, we're currently of the opinion that the fees should be limited to 5 times the investment. And that actually made many people very nervous. But that was, of course, just one judgment, and we have so many other judgments in which the district courts took an entirely different turn. So I think it's still very much too early to tell how that is going to develop.
And Carlos, how about in Spain?
So first of all, yes, loser needs to pay winners legal costs, but to a certain extent, which is fixed by local bar associations. In terms of funders' returns, there is no cap, and arguably because litigation funding agreements are based on non-recourse financing, there are no usually limits, because at the end of the day it's a different scheme than loan agreement. So I would say that when it comes to opt-in, which is what we currently have in place, there are no restrictions, so it's free market. And when it comes to the implementation of the directive, there's going to be, or there may be some changes, because in the opt-out system, which at least was envisaged in the earlier draft bills, there are some provisions stating that in an opt-out class action, if defendant loses, well, defendant needs to pay, and then all the claimants need to raise their hand. So I'm here, please give me my money. So what happens with whatever is left in court? So in principle, that potential upside wouldn't go to the SPV. That potential upside would go to the defendant. So in that specific world of the implementation of the directive, there might be some changes. It is true, though, that regulation will refer to litigation funding agreements, but not to other sort of structures. So we'll see how that gets implemented in Spain eventually.
And Rosie, given the different regimes, there's quite a lot of tactical thought that goes into picking the right jurisdiction and the right procedure. You obviously fund across Europe. How do you see the challenges and the opportunities?
Yeah, I'm often asked this question, kind of where do we like to fund, and what types of cases we like to fund in the group action space and in the collective redress space, which jurisdictions are hot and which are not. And my answer is always pretty much the same, and I think people have probably heard it quite a lot before. So I will address your question about the challenges first. And from my perspective, there are two key challenges in funding collective redress across Europe, no matter which jurisdiction in which we're funding. The first is procedural uncertainty. So in so many jurisdictions, the procedural uncertainty is real in terms of collective redress. The Netherlands introduced the Rwanda regime, and it was the panacea to collective redress in Europe. Turns out it might not be. And then there was a lot of talk about the introduction of the directive in all of these various different jurisdictions. I think the statutory regime that is going to be introduced by the directive is going to result in an awful lot of unanswered questions operating in the market for a long time. And so is it actually better to be proceeding along the established route for group action regimes that we already know about, where you're book building and you're opting in? And so these opt-out collective regimes and the procedural uncertainty that comes with it is, for me, the number one challenge. However, I'm an eternal optimist, and I do think that procedural uncertainty will be resolved in the short to medium term. And the reason for that is because as the cases work their way through the courts, we are going to get decisions from appeal courts and ultimately potentially from the ECJ, and that is going to be helpful for everyone, and hopefully in the interest of consumers and the claimants, going to result in far quicker resolution to these claims, which is important. I think the other major challenge actually is a lack of education among the legal community in all European jurisdictions about the benefits of group claims. And at the moment, there are so many naysayers out there about group actions, its benefit for claimants, but its benefit for the progress of litigation through courts. If one looks at the truck cartel in Spain, for example, and the proliferation of actions in that jurisdiction, or the emissions claim in Germany and the need to progress those actions on an individualized basis, the naysayers need an education, in my view, as to the benefits of the group action regime, be it on an opt-out or an opt-in basis, and the efficiency of running those claims on that basis. And I think a real challenge is that lack of education and knowledge at the moment, which again, I think is going to be resolved in the short to medium term. So they're the challenges as I see them.
Thank you. In the time that we've got left, I'm going to ask each of you to maybe give a prediction for what we might see in the year ahead. Carlos, I'm going to start with you because one thing that often comes up is whether there is a market for defendant funding, and it's economically often quite difficult. You don't have to limit your answer to this, but as I understand, that is a market that you're starting to see develop quite fast in Spain.
So we think that is an opportunity there for various reasons. So first, obviously, depending on the likelihood of adverse litigation, that means creating a reserve and an expense in the accounts, and that can create director's liability based on companies law. So not having any solution in that respect, it's an issue for corporations. Second, well, in some of cases, we know that, particularly in follow-on claims, there is a reasonable likelihood that there will be liability in court, but there is probably a delta between the alleged overcharge and what can be adjudicated in court. So there can be room for some insurance product above and beyond certain self-insurance level. But of course that's costly, so somebody may need to fund that premium, so that can be an opportunity to do some sort of swap of related products, because maybe those defendants can also have some claims, so there can be some sort of area for creativity for both insurers and litigation funders.
Thank you. And Marc, how do you see the year ahead in France?
Well, clearly there has been in the past few years a lot of developments in France in terms of collective actions. A number of funders have started first opening offices in Paris, started funding actions in France in general in various domains, whether it's antitrust or other fields. So the market is, I would say, unlike other markets in Europe, which are already very mature, there are a lot of actions that can still be brought in France that have been brought elsewhere. So in my view, there will continue to be a lot of B2B actions in the next coming years. And regarding consumer actions, I have more doubts about that, mainly for the reasons that Rosie mentioned. But it remains to be seen what the final transposition of the law will be. But in my view, this will be slower. The developments in that area will be much slower than the B2B space.
Thank you. And you?
Well, I think in the Netherlands, in the short, mid-long term, we will see much more issues being clarified, such as formalities regarding claimant organizations, the commencement of class actions, things like that. I think the more material things that we will see develop in the coming periods is one thing, how to deal with particularly immaterial damages in GDPR-related claims, because there's quite a number of GDPR-related claims pending at the moment, and immaterial damages is one of these open issues which in some way needs to be decided. The other thing is, and that one relates actually to the loser pay rule, because we do not have a true loser pay rule in the sense that loser pay rules in the Netherlands only lead to economically irrelevant cost orders, except for IP cases and the new and claims under the new collective actions regime, class actions regime, because there the defendant can be ordered to pay costs in case it loses a claim for damages, and that it's pretty new. We don't know how it's going to play out, and the argument that we've made a couple of times already is that since it simply mentions to costs to the extent not unreasonable, that's how it's stated in the law, that should actually also include the fees owed by a claimant organization to a funder.
And if that is the way it's going to be approached by the courts, that actually could open the opportunity to fund cases which have a relatively small value, because then you could actually solve the cost issue and the cost order issue in the agreement between the claimant organization and the funder. But that is, well, I'm very much looking forward to the first judgments on that, and that's probably going to take quite some time, because if cases get settled, we will never know how this is going to play out.
Thank you. And Alberto, how do you see the Italian market?
I think that we have an interest that didn't exist a few years ago from international fund and for investing in Italian litigation. I think that this is quite substantial, and we are working on different cases, and this is very interesting. Then obviously there is this new aspect of the class action. The figures I gave before give an idea that there is a lot of thinking on how to use the new instruments, and therefore we will see if then will produce results. Certainly, also in my view, as it is in France, it is easier in the short term that we will see developments of B2B, and for the consumers it will take a little bit more time. Also consider that due to the directive there is an analysis of the court in respect of the finances of the action with the class action for consumers, which can bring an analysis of the cost. While for the funding we have no limit in respect of the fees up now, then we will see in the future.
Thank you. And last but not least, Rosie.
With my eternal optimist hat on, I think the next year is going to be characterised with settlements, and those settlements themselves are going to generate a very interesting discussion about the distribution of proceeds, settlements in cartel claims and how it operates as between payouts and the procedural fallout from there, which will be an interesting economic and positive discussion. But I think we will be seeing that in the collective action space, and we will be discussing interesting developments there this time next year.
Well, thank you, panel. Do we have any questions? Yeah. Oh.
Thanks. Hi, I'm Guilherme from Brazil, a lawyer from Brazil. We have been experiencing in Brazil in the past years collective arbitration, class arbitrations. My question is, are you seeing this kind of arbitration in your countries? And if so, which matters are being discussed? In Brazil, we have corporate and securities disputes in these arbitrations. Do you, in your countries?
No.
Thank you.
Well,
no, but I think there's. Can I say something about that? Because I think there's a very important difference between Brazil and at least the Netherlands, but I think the same goes for most European countries. Arbitration is there's always an underlying agreement, and I recall that in Brazil, in some situations, arbitration is actually prescribed by the law. So I think it is in fraud on the market cases in Brazil, it is mandatory to submit the matter to arbitration. And that is a very special situation in Brazil, but we do not, as far as I'm aware, we do not have something similar in the Netherlands.
I think there was a case in the US relatively recently where a claimant law firm sought to bring a class action in the court, but it was a B2B case, and all of the underlying B2B agreements had arbitration clauses, and they were made to transfer it to an arbitration proceeding in the US.
Actually, in Brazil, it's not prescribed by law, but by self-regulation rules. So some companies, they must have this arbitration clause in their bylaws. That's why it's mandatory.
Yes, and we had there was actually a link, of course, between that and the Netherlands, because in the Petrobras case,
There was that case was of course settled in the US. There's still pending arbitration in Brazil, and then there's a claimant organization which brought a collective case in the Netherlands under the old regime, so declaratory relief only. And in that case, actually Petrobras made the point, you cannot bring that case here because we have this arbitration clause in our bylaws. And then the Rotterdam District Court decided that that arbitration clause was not unenforceable, and now it even becomes more hotter than ever. The district court even decided that that arbitration clause as such was contrary to Brazilian law.
Anyone else? Okay, well, thank you very much.
Thank you. Thank you.